I didn't think that there was that much to talk about.
There's a lot to talk about.
Hey everybody, welcome to American Courts. I like that little clip with Judge Middleton and Deborah Davis. Him thinking there wasn't that much to talk about. And she's like, oh yeah, there's a lot to talk about. I bet you she could write a good little book about her struggles over the last couple of years and how she's made it to the top of her game right now. So congratulations to her. Thank you for all the subscribers. Thank you for all the members. Thank you everybody for coming out tonight. We got a pile of people in here and it looks like we're about ready to get started for the show. Let's jump over to a Judge Middleton one. Since we're here, let's jump over to that.
All right, Mr. Fleming, thank you. Everybody is back. It's time to start this arraignment. This is called a bail setting arraignment. Sometimes we refer to them as jail arraignments, but it's to get the case started after your arrest, advise you of the charge, and set a bond. The prosecutor filed a complaint this morning, I think, alleging that on or about Christmas Day, December 25th, you did assault, batter, wound, resist, oppose, or obstruct Nathan Johnson, Brian Freds, and Joshua Edgington of the Sturgis Police Department. Those are all felonies punishable by up to 2 years imprisonment. It's also alleged that you are a habitual offender with at least 3 prior felony convictions, making this a 4th offense, which on a 2-year, I believe, makes it a maximum of 15 years imprisonment. Prosecuting attorney-elect Deborah Davis is here with us, and you met with the public defenders, Keith Stickley, the chief public defender, and his assistant, Larry Westcomb. Ms. Davis, let me ask you this. The bond information sheet refers to a fleeing and eluding incident earlier in the day. There's no fleeing and eluding component to this.
Your Honor, there is a warrant request for fleeing and eluding from Officer Joshua Wired from the Sturgis Department of Public Safety that is in review. There were some questions about jurisdiction and other charges that may be associated with this. There was an incident in Sturgis, which is what brought the police to the place where he lives, and he then was seen in his vehicle. And there are 4 separate jurisdictions that have potential fleeing and eluding charges, all from yesterday's incident, which is why I'm here to advocate for some bond conditions and potentially not allowing bond in this case because of the danger to the public that this individual presents. So I don't know if you want me to go into that.
Go right ahead.
Sure. So this particular defendant was just released from parole recently. He was on parole from an incident of resisting and obstructing, causing injury to an officer here in St. Joseph County. He has several prior domestic violence charges, including domestic violence 3rd and a strangulation. He has been charged with absconding previously because he hasn't appeared, and his behavior yesterday is extremely reckless and dangerous. This started in the early afternoon. It's alleged that his significant other, who was the victim of one of his prior domestic violence charges, had called the police to assist her because he was being violent and breaking things at the home, and she alleged that he is using methamphetamine again since he's been off of parole for a few weeks. So with that, the officers waited to see if he would come back because she said he had left driving erratically. He did, in fact, pass by the officer on Nottowell Road going 100 miles an hour in a 45-mile-an-hour zone. It's alleged that at that time, Officer Wired did pursue the defendant, but that pursuit went through multiple townships and the village of Baroque, and then into the state of Indiana, where it had to be terminated. Shortly thereafter, it's alleged that LaGrange picked up, they found him, and he then fled from the LaGrange officers back into Michigan. It's alleged that they then lost him again, and then he went back into Indiana and then came back to Michigan, where St. Joseph County deputies found him and pursued him, where they lost him again. And then Officer Wired in Baroque Township found him again and pursued him. But because of his driving being so dangerous, passing people on the right side, that sort of thing, they terminated the pursuit. And then a tip led them to find him last night in Sturgis at the American Inn, which is where this RNO ×3 was alleged to have occurred, because he refused to come out of the hotel room, physically was holding the door shut, preventing the officers from unlocking the door. And then they found him in the bathroom, again, not coming out with the officer's lawful commands. So as far as the danger to the public, I think as far with his driving and the issues, he does have a valid license, which is surprising based on the fact that he has 3 prior OWI incidents in different states. He has criminal history in several different states, including a flee and elude in West Virginia, and some incidents in Indiana, multiple different instances of use of controlled substances and assaultive, threatening behavior, multiple prior assaulting, resisting, obstructing of police officers, although some of them were dismissed as part of plea agreements. He is an extremely dangerous person in the view of the prosecutor's office, and we would ask that the court consider not allowing a bond at this point because of the danger to the public, as well as the likelihood that he is not going to appear. And if he doesn't appear and a bench warrant is issued, it could be an extremely dangerous situation for the law enforcement involved, as well as the public, if they have to go out and chase him and find him again. Again, there's also going to be at least the flee and elude from Sturgis that is under investigation because of the potential for the methamphetamine, potential for an OWI or OUID. There was some further investigation that was supposed to take place this afternoon. I'm not sure of the status of that yet. So we went forward with just authorizing on the resisting and obstructing, which we're prepared to have a trial on those pretty quickly. If the court wants to set it quick, we can. I would rather have this individual stay in custody and not be able to have access to vehicles or substances, so that we can have a trial sooner rather than later. And because he is a 4th habitual, the fleeing and eluding will likely be a potential life offense.
All right, the fleeing and elude could be a 5-year with a 4th habitual. Mr. Fleming, the public defenders are here with you. Let me ask you a couple questions. I show your address as North Street, Sturgis. Is that correct?
Yes, sir. Yes, sir.
All right. So the room at the American Inn, Mr. Mr. Cannon's room, you didn't reside there. You just happened to be there.
Mr. Fleming, I'm going to advise that you not answer that question. All right. Your Honor, we would ask that the court respect Mr. Fleming's right to stand mute, have a not guilty plea entered on his behalf.
All right.
And then we have we would have a brief, I guess, rebuttal in terms of bond.
All right, Mr. Fleming, in interest in protecting any of your rights, the public defender's recommendation is you don't say anything. And some of it may be moot because I'm going to deny your bond. So there's no point in asking whether you're employed, I guess, or where you live. I'll speak to the reasons for it here in a minute. But Mr. Stickley's advice is probably wise. So at this point, I'm going to show you stand mute, plead not guilty. I'm going to appoint an attorney for you. I'm going to set a pre-exam conference for January 7th of 2025 at 8:30. Pre-exam conference for January 14th, 2025, if needed, at 1 p.m. Mr. Stickley, what else would you like to place on the record here?
Your Honor, the only other thing that I had to place on the record this afternoon, is that the defendant understands that the court might have reservations about what kind of bond might be set. MCL 765.6 does lay out that the defendant would be entitled to bond and that bail shouldn't be excessive if not addressed by some other statute. On the list of no bond acts, allegations in Michigan, I'm not sure that this qualifies as a no bond.
I had a concern that a 2-year R&O would qualify for no bond. So let me look at the rule. But go ahead.
And that is my statement, Your Honor. I was not able to find where resisting and obstructing an officer was one of the enumerated no bond conditions as referenced. I know the general overall rules MCL 765.6. I was trying to find, as you know, it's broken out a little bit helter skelter, but
Yes.
I don't believe that is a qualifying offense to a no bond condition.
All right. This happens a lot. The courts will set a bond at $1 million. And what they really want is they don't want the person to bond out. So rather than say no bond, they set a very high bond. That's somewhat disingenuous. The legislature is working on some bail reform statutes that I don't think got over the hump at the end of the last session. And talking about eliminating different types of bail. Anyway, the case is aggravated. You're a very angry young man, have been for some time. I'm not sure everything that's going on here recently, but you have several previous assaultive offenses. 2013 assault, great bodily harm, bound over to circuit court. 2014 809 FY, 2 counts of resisting and obstructing, bound over to circuit court. 2014 941 FY, absconding on that R&O charge, bound over to circuit court. 201920 assault, great bodily harm, felonious assault, resisting and obstructing with an injury, and fleeing and eluding. That was bound over to circuit court and you went to prison. That's the one you're on parole, just got off parole on. File 201972 was a domestic violence third offense felony charge, bound over to circuit court. You had an assault and battery and MDOP in my court in 2021, I think, while the other case was pending, and you never ended up paying the fine and costs. Ms. Davis also indicated there's some out-of-state charges, including a fleeing and eluding in another state. The resisting and obstructing here is not that egregious. You went into some other guy's hotel room and wouldn't open the door for the police. It's like a child hiding their head under a blanket thinking maybe nobody would see them. And then it read like a bad movie where you're hiding in the shower. They should have turned the water on. Anyway, that's how you finally got arrested, and they were resolute in their attempt to take you into custody. The reason that I considered all of this stuff, but there are more charges coming, and it would be not a great situation to have you bond out on this and immediately get rearrested on some new charges. So my intention was to deny the bond, at least until the time of the pre-exam conference on January 7th, and see what else gets charged, which would be more honest than setting a very high bond that you couldn't post. But Mr. Stickley pointed out a fear that I had. There are certain cases you can deny bond for, and I'm not certain that the actual facts of this case, where you wouldn't open a hotel room door, generally wouldn't merit a denied bond. you've got a bunch of baggage in your past and a bunch of baggage in your future. But there's good reason, public safety reason, to not let you bond out pending the new charges. So we will set a bond as Mr. Sickley requests. Bond set at $200,000. Cash or surety. This sounds like methamphetamine with a capital M, but we'll see how it plays out. I'm glad no one was hurt. Yes, sir.
There's no drugs involved.
All right, well, that's a plus. Just anger, I guess. And you and I have discussed it. You're angry. So, I mean, you drew a crappy hand, I'll grant you that, but this isn't the way to resolve it. Billy Joel wrote a song called Angry Young Man. I used to have the lyrics taped inside my briefcase when I was in law school.
You remember me when I was a kid?
Yes, I do. I remember your brother and your sisters. That's what I'm talking about. You get
brother. I don't have a brother. I got a sister that was molested. Now
yes,
you
I
remember?
remember. I was the guy that prosecuted the case.
Yeah, I know you was. You was the one that let him off.
I didn't let him off. He ultimately was convicted. He was acquitted in the first case, and we had a second one. That was almost 40 years ago. And no, I didn't let him off. He ultimately, I believe, went to prison.
No, he didn't. You let him off. Child molestation.
All right,
You let him
All
go.
right.
let's
Hold
tight.
all right.
Mr. Fleming.
Anyway, we'll leave that song lyric for another day. No drugs and no alcohol. No driving. Test if directed. I don't think you're gonna bond out. We'll see what comes of these new charges. Yes, Mr. Fleming, I remember when you were a kid and you got a lot of pent up anger you're still dealing with. All right, sir, I'll see you on January 7th. Your attorney will come out to the jail and see you.
Thank you, Ron.
Thank you. The line goes, I believe I've passed the age of consciousness and righteous rage. I found that just surviving was a noble fight. I once believed in causes too. I had my pointless point of view, but life goes on no matter who was wrong or right. I'm gonna put that last part on my tombstone. Life goes on no matter who was wrong or right. He was very young. Okay, I got a waiver to do. Deborah, I don't think you need to get involved in that one, but we'll wait other charges on this.
So that guy had a good reason to be mad. 40-something years ago, his sister was molested, and he felt somehow that Judge Middleton, back when he was a prosecutor, let the guy go. I trust Judge Middleton's memory a little bit better, and Judge Middleton showed that he was acquitted on the first one and got convicted on the second one. So I can understand him being angry, but don't mess up a Judge Middleton singing the lyrics of a song. There's something sacred about that. So the next one we got is Old Squishy Gardner. He got Judge Webster with a good one the other day. I didn't see this one going, so thank goodness Old Squishy Gardner found it for us. So we're gonna play it now. But make sure to check out his channel, like and subscribe and all that other stuff. And then you don't have to because everybody's already subscribed to him. So you just go and watch some more videos and like everything, and it helps his channel out. Here we go.
You will check in tomorrow morning at 9 a.m.
And if I don't,
Then I will send the sheriff after you, and you'll most likely serve 6 months in the Butler County Jail.
because you want to send me to jail, how is that
All
helping
right,
you?
then we have Mr. Bauer's client.
And I'm sorry, Judge, what was that name?
It is Annie Scott.
Yes, Judge.
Okay,
Here.
will now be on the record in 2020 CR 82, State of Kansas versus Annie Lee Scott. This is a show cause. How does she wish to proceed at this time, Mr. Patterson, on the allegations that she has violated her probation for driving while suspended, leaving the scene of an accident, and giving a false alarm?
Your Honor, I would tell the court that I have spoke to Ms. Scott. I would tell the court that she is going to waive and stipulate. She would stipulate specifically that she had not kept in contact or reported to a probation officer as required. And there'd be an explanation of that, Judge, that their phone was it wasn't her phone. She was having trouble with the phone issue. Also, that she had not gained or maintained employment during her probation, although I think there's some issues there. There's an addendum, Judge. And on the addendum, there lists a new case. That is a pending case. It's not something that would be stipulated to for purposes of the probation violation. And I would tell the court that, again, at the time of disposition, she's had some major changes in her life that we'll want to put on the record for disposition.
Okay, Ms. Scott, this motion to revoke your probation was filed. The motion was filed May 18th and the warrant was issued May 19th. So we've taken some time getting here today. Is it your intention to admit that you had late and missed appointments and you hadn't paid anything on your case as ordered?
Yes.
Is anyone making you admit these violations of your probation today by any kind of threats or promises?
No.
You understand you do have a right to an evidentiary hearing in which the state would have to call Mr. Bauer and see if they could prove that you violated your probation?
Yes.
And knowing that, you wish to waive the right and again stipulate the violations.
Yes.
All right, I accept your waiver of your evidentiary hearing and your stipulation that you have violated your probation as alleged, at least in the original warrant, and find that you have violated your probation, which exposes you to a 6-month controlling sentence for these charges. Mr. Sweeney, you have recommendations for disposition?
Yes, Your Honor. Generally, what I would recommend in a felony case similar to this would be some sort of jail sanction to be served forthwith, and that the defendant be placed back on court services probation with the same and previously ordered conditions. This isn't a case that I've spoken specifically with Mr. Bauer about, so he may have his own thoughts and beliefs regarding her performance on probation. I would think somewhere in the range of 2 to 5 days as a jail sanction might be appropriate, and then have her immediately placed back on probation with Mr. Bauer.
Can I ask?
I may defer to Mr. Bauer if he has any other additional recommendations beyond that.
Mr. Patterson, do you have a preference? Do you want to hear the probation officer's recommendations first, or do you want to proceed first?
Judge, I would like to go ahead and present, because there might be information here that is not known by Mr. Bauer, so that whether it affected or not, I just want to make sure that he has this information.
Very well, please proceed.
Judge, after talking with Ms. Scott, I would tell the court that this is a case where the original charges were from February 14, 2020. Ms. Scott, can you mute yourself for a little bit? Judge, as I stated, the original charges from February 14, 2020, they didn't get resolved until December of 2021 when she was placed on probation. Part of the reason why they didn't get resolved earlier is she was in Department of Corrections, DOC, that she had been released in November from her DOC sentence. There was a hold on her through Butler County. She was transferred to Butler County to resolve this case. So when she got placed on probation in this case, she had just gotten out of prison, had basically nothing to set up to move forward and be successful. There for a time, it appears that she, in effect, was homeless. She was relying on other people's phones. She was having difficulty even having a phone that worked during that time. She didn't have places to live, but through time and effort, Judge, she has now a stable living environment. She's been able to get assisted housing. She lives in Wichita now and has a house. That further that she started a University of Phoenix program to try and better herself through education, and she's currently in that. She's looking for employment currently, and she would report that she is sober. She also has her own cell phone at this point. So through a lot of effort on her part, she's starting to get her life turned around to where she has an opportunity to be successful on probation. So we would ask the court to allow her to continue on probation. We would ask the court, if the court is inclined to have a sanction period for her for violations, that she be allowed to do that on a weekend. She does have transportation problems, so she would have to work around those transportation issues from Wichita. But we would essentially ask the court to grant her to return back on probation, Judge. Thank you.
Now, let me see if I got this straight. When did she get out of prison?
November of 2021, where she was then transferred to Butler County because of a hold. And this case then was heard in December of 2021.
So did she sit in jail for quite a while between November 21 and December 21?
Judge, I don't know whether she bonded out right away or whether she stayed in there until sentencing.
And then she has lived where since she got out of prison?
For quite a while, Judge. I think she just tried to find places to live with friends or family and almost was homeless. But now through assistance and assisted living, she's got her own place. So she is set up and has a home. So going forward, she will have a roof over her head, a permanent structured place, as well as looking for employment now, and is currently going to school.
So when she got out of prison, did she have any parole, conditional release, anything like that she had to answer for?
She tells me that she has been released from parole early and is not currently on parole.
And why is she not reported to Mr. Bauer?
She did not have her own phone. She basically did not have anything to her name, pretty much. So she relied on other people. She didn't have phones that worked at times, but now she has her own phone.
What's her source of money now?
She's currently unemployed, but looking for employment, Judge.
So how's she paying for a phone, eating?
I don't have that information. That might have to come from Ms. Scott.
And do I correctly understand that this situation that she had the warrant out of Hayesville, this pending case is for one prior to incarceration in DOC?
That I don't know, Judge, but I know that it's still pending, so it's not something she would be stipulating to at this time.
Okay, I understand. But if I may ask, Ms. Scott, is that allegedly for a case allegedly committed prior to going into DOC? Just keep a very yes or no answer to that.
Yeah.
So, okay, next question. No one's alleging you've committed a new violation of the law?
Correct.
And who is paying your telephone and your food bill?
Me.
How do you get the money?
I have food stamps,
Mhm.
and I just moved into my own place. I had taken out a loan.
I presume this was not a loan from a bank,
Correct.
so it's from an individual?
Probably a student loan, Your Honor. Is that right, Ms. Scott?
Yeah.
Oh, okay, a student loan. So you're living off of a student loan and you're back in school?
Yeah.
All
I
right.
don't know what my fines and fees are, but I have another lump sum coming around like November. So I mean, whatever that is, I can pay it.
Okay, well, you know those loans are supposed to be paid back, and you need to use them for school. Rise when you get out of. So, Mr. Bauer, I'd like to hear from you now.
Correct, Your Honor. There's not been any payments made. She owes $768. I would agree with Mr. Sweeney that some kind of a sanction. I think a 2-day sanction probably would be plenty, but some type of a sanction and then place back.
All right, Linus, you want me to explain food stamps to you? In the United States, if you make under a certain amount of money and you apply and you meet the criteria, you get a card that helps you buy food. It's made for people that are in a bad situation, single moms, families that are just underneath a certain level of income. There's a stigma to it. There's people stereotyping it. There's a lot of abuse for the system. I know whenever I was a kid, people that were on food stamps would trade $100 worth of groceries for $20 worth of cigarettes, or they would trade food stamps for cash. I don't know how it works these days, but I know it's like an ATM card, but you can only buy certain stuff on it. Yeah, Fozzie's going to answer you there so that way we can get started and I don't stick my foot in my mouth about it.
On probation, I'm willing to continue to work with her, but the main thing with her has been lack of communication. She did get through parole. She got off of that early, but she was reporting to them and taking care of that. While she was on parole, I really didn't do a whole lot about the not reporting because she was reporting to parole. But since she's been off parole, she hasn't been reporting. I haven't talked to her since early June. I think the key thing for her is stay in contact with me because I can work with her on all the rest of the stuff if she communicates with me. Last I knew, she was homeless, living in a shelter, and had no phone. So her going to school and all this is new to me. I have not been aware of that.
All right, Ms. Scott, you've gotten a couple of redos in life, it sounds like, with your parole, and it sounds like these folks are willing to work with you on probation if you're willing to work with them. Are you willing to report as directed and follow your probation conditions?
Yes.
I'm not sure a 2-day sentence is going to make a difference if you've already done prison time.
Every day I sit in jail, that's another day that I work so hard to get where I am right now. Whatever.
But I can't just, here's the thing, Ms. Scott, I can't just ignore the fact.
I can go to jail, it's fine. I'll throw everything I have away. It doesn't matter to me. It really doesn't.
Okay, first of all, take a deep breath and sit down.
I already lost my mom and you guys want to keep taking my freedom
down.
from me.
Ms. Scott, sit down and take a deep breath. If you can't even follow the court's instructions when I tell you to sit down, you're not going to be able to follow my directions when I tell you to report to the probation officer. How long were you in DOC?
I did a 5-month sentence. And you guys, they still brought me back to the Butler County Jail after the fact. They knew my mom died. They knew. I had to have, my family wouldn't even bond me out to go. I had to have my ex-boyfriend do it.
Okay, but Miss Scott, listen to me. Probation is a privilege. I don't owe it to you. You committed these offenses and you have to be responsible for them. Now, Mr. Bauer has said he's willing to work with you, but you've got to at least report. If you don't want to be in jail, if you want to be able to do the things you want to do, then you have to report. Now, if you still want to be on probation, I can't just ignore the fact that you quit reporting and quit doing what you're supposed to. I do have to give a sanction. Mr. Sweeney and Mr. Scott only are asking for a couple of days, 48 hours. That's pretty minimal. Instead, I realize you've served 5 months for something else you did. But where do you live right now?
I live in Central County. I live in Wichita.
Okay. And you don't have a valid driver's license, is that correct?
No, I don't.
Okay. I will work with you a little bit to get over here to the county jail, but you're going to have to serve 48 hours and then report to Mr. Bauer. If you don't want to do that, I will just revoke your probation now, and I'll send the sheriff over to get you. Want to do that?
I'll do whatever you want. I will literally start packing my stuff right now.
Okay. Now, you don't have a job at this time, right?
No, but I have a home that I'm trying to take care of.
And you go to school. When are your classes?
I go every week. There's a new, they're 5 weeks long, but it doesn't matter. I'm going to jail anyway.
Are they on the computer? Would you please sit down? Is this the way you would act in my courtroom?
I'm just trying to pack my stuff, so I have to
down, or I'm going to send the sheriff after you.
Out of my house.
Mr. Patterson, anything you can do to tell your client to listen to me and cooperate? Because she's not acting like she's in court right now.
Judge,
I just have to get my stuff together and have somebody come pick up my belongings from my house since I'm about to.
If I could have a brief breakout room, maybe I can get
very brief, Mr. Patterson, please.
Thank you, Judge.
Back on the record in State versus Annie Scott. Mr. Patterson, has the client been able to have a meaningful conversation there?
Yes, Judge. She's ready for the court to proceed with disposition.
Scott, is that right? You're ready to proceed now?
No, I'm not ready to. I'm not ready to go to jail. I'm really not.
Okay.
I just had a job interview and I was waiting on a call back, but it doesn't matter.
Miss Scott, can you at least sit and listen to me? You see, I have the opportunity to order you to go serve 6 months in the county jail or a couple of days. I don't have to order anything at all. Do you understand that I have a wide option there? Okay, well, I'm telling you I do. And your response to my questions are going to help me decide how much time you should do. Now, the recommendation from the state has been 2 days. They're not asking you to do the whole 6 months. So what I want to know is, you're living in this house, and who's paying the bill on the house?
Me, I am.
Through your student loan money. Is that right?
Exactly.
How often do you go to school?
It's all year. The program started in February.
Is this online? Do you go to school online, or do you go sit in a classroom?
Yes.
So your college is online. Is it college that you're taking?
Yep.
What's your major area of study?
Business.
Business administration,
business administration.
And what school are you enrolled in?
University of Phoenix.
All right. So you do it, you work at your own pace, basically, as long as you get done within a set period.
Yep.
You don't have a job, is that right?
Right. I just had a job interview on Friday.
When are they going to call you back or notify you about whether you're hired or not?
Today.
Where would you be working if you're hired?
Subway.
And is that in Wichita?
Yep.
And how would you get to work?
It's not far from my house, so I would just walk.
Okay, that's good, because you still don't have a license, correct?
Correct.
Right. I am going to order that as a consequence for your violation, as a sanction, you will serve 48 hours in the Butler County Jail. And you will check in tomorrow morning at 9 a.m.
And if I don't?
Then I will send the sheriff after you, and you'll most likely serve 6 months in the Butler County Jail. It's that simple.
This literally help.
Miss Scott, if you're not hearing a word I'm saying, if you're not going to cooperate, I'll just full 6 months served.
It's fine. My life is over. Thank you. Thank you so much.
Right. All right. I'm going, it's your call. I'm going to give you one chance. Do you want to bring yourself over here tomorrow at 9 a.m. or do you want to serve the full 6 months?
This job. Yeah, I'll come. I'll do it. I'll do whatever you want. I can't.
9 a.m. tomorrow morning, deputy, if she's not in the county jail, then she will serve. And Mr. Patterson, make sure we understand this. If she is not here at 9 a.m. tomorrow morning and serve 48 hours and immediately report after she's released to CSO Bauer, she is to serve the full 6 months.
I can't fucking do this. I can't do this. I can't. I fucking can't.
Ms. Scott? I'm sorry, Mr. Bauer. I don't think she's going to work with you. You still want to give her a chance?
If she will do her sanction and report to me, I will give her an opportunity. We've had this same exact type of episode in a meeting, so I'm not completely shocked about the behavior, but I will work with her if she's willing to try.
So with your experience with her, does she calm down and then behave, or does she just disappear on you?
When she did this to me, she hung up and then called a few days later.
Well, if she doesn't show up tomorrow and waits a few days later to call, there's going to be no mercy. Do you understand that, Miss Scott?
There is no mercy now, so.
Okay. Guys, I'm going to order that her probation is revoked. If she doesn't bring herself in within 2 hours, the sheriff needs to go pick her up.
I can't get there in 2 hours. I don't have a ride.
All right. Probation is revoked. Issue a bench warrant for probation.
Because I don't have a ride.
And go pick her up, because this is not going to work. I can tell this behavior is not going to be conducive.
Because I have pled my case. I've pled my case. I've worked really hard to look, this is my house. This is my home. I have no furniture because I just got it.
And I have been willing to work with you, Miss Scott, but you just will not work with me.
Because you want to send me to jail. How is that helping?
All right, I'm not going to do this, Miss Scott. Probation is
That's
revoked.
because it's not helping anything.
Case is closed. Case is closed. And when I say closed, case is closed, I mean case is adjourned. It's not closed, but this hearing is adjourned. Mr. Sweeney, if your office can get the bench warrant to me, I will order it. Probation revoked, defendant sentence. Okay. We'll be in recess. You can, what's your address, Miss Scott? Miss Scott, what's your address?
And she left.
And she left. She obviously bent down and disconnected. So probation is revoked. She will serve her full sentence and warrant to pick her up.
These two trucks out of
Yes, Your Honor.
It looks like
So
my
AA was corresponding with you by email with regard to the establishment of child support base. Could you please update me like where we're at and what's needed from me at this point?
Absolutely, Your Honor. I will note for the court's record that both parties were totally compliant in getting the information that we needed. Part of the difficulty in this case, and is something that you mentioned in the last hearing, is that the children were kind of moving around without the court's order. And as such, it was really difficult for DCF to maintain a consistent case number with the appropriate children listed with the appropriate parent. So each time children move back and forth, that messes up the way that our cases are set up. So it took quite some time to get that part worked out, Your Honor. So I apologize for the delay, but I will note that both parties have been completely compliant, have totally been calling in and to give information. So, and I apologize for the delay. I did run a child support worksheet on September 5th of 2024. That came out to Ms. Sharp paying $506 per month. I used an average of 3 pay stubs that were provided by, I'm going to mess up last names. I'm sorry. Can I use first names?
Yeah.
Kyle. So I used an average of 3 pay stubs from Kyle, and I used an average of 3 pay stubs from Malia. Kyle's income came out to $2,866 per month, and Malia's income average of 3 pay stubs was $2,075 per month. Kyle is carrying health insurance coverage through the state of Kansas on the children. There is no cost for that. And I gave Kyle the ability to claim the children for tax purposes with a $111 adjustment given monthly to Malia. So my request today would be that the court set support at $506 per month payable by Malia effective 5/1 of 2024, which was the date indicated in the order that you previously signed in June for the effective date of support. That Kyle continue to carry health insurance on the minor children and claim the children for tax purposes.
Okay. Do we have any objections to that or requests to seek independent counsel?
I actually do, Your Honor.
Okay.
So when we first did this, it was from November of 2023 when our divorce was final. And we had said that Malia had 1 child for 4 months. 4 months. And then at March, I had all 3 children. And then from April on, I had 2 children and she had none. That was in the last court. That's exactly what the order was that you put, that she was supposed to pay back child support as well.
Well, I can't order back child support for a placement that you all did without notification to the court and a motion to modify child support. I can't go back and resurrect what people have been doing for 2 or 3 years and then decide who owes what when there's already existing order in effect.
I'm confused because I changed it from a child support to a custody thing in that last one on the last court date in May. It wasn't over child support. We withdrew that one and put in another case for custody because the custody that was set was she had Linnea and I had the other two.
Well, this does go back to May, but it doesn't go back to 2023.
When we got divorced in November. So I've carried the kids for a year now by myself with no one to help. She hasn't
because you are self-represented. I told you numerous times to seek an attorney or get with DCF or a contract attorney to file a motion and submit a proposed worksheet. I can't work as an attorney and do all that for you. So if you want
I did everything.
It would have been worth it for you to hire an attorney to do the calculation solely for child support, to bring it in front of the court, give her notice, and request it and get it ordered. Now, Ms. Soretti, is there any other arrearage that is owed by either party other than her obligation that is dated back to May 1 of 24 when the formal motion and hearing occurred?
No, Your Honor. The original divorce decree that was filed in November of 2023 did not have child support ordered. So there is no arrearage that could have been calculated prior to that motion that was filed in April of this year. So Mr. Smith filed a motion in April of this year to modify the journal entry, include change in custody and child support. Once that motion was filed, I think that's where the May 1st effective date came from, because he filed a motion for child support in April, and the statute requires that support be set 1 month following the month of the filing of the motion. So that was our effective date, May 1st.
The only thing that I could have done differently, and as I recall, this got drug out several times for me to finalize. The only thing I could have done different is just not giving you a divorce at all. And said, I'm not making custody decisions. I'm not divorcing you. I'm not doing anything because you don't have child support.
Honestly, Your Honor, I don't understand why that wasn't set in the first place. I'm just going to be honest.
Because it was never computed and never submitted and never up.
I tried. So you gave me a gentleman's number from Topeka from Child Support Services, and I tried to call them and they didn't. And then we did all the paperwork once before. In November, we did this. I've done this multiple times. And they said it would take so long. And then they said it was because the custody was all messed up because of the way we did it. So that's why I went back to court and made sure that there was a full-fledged custody set in place. That way no one could question.
And that's where I'm granting your child support file, period. You have no proposed child support worksheets filed for approval by the court in this court file. So I don't know what you're talking about, what you did or didn't do, but you had plenty of opportunity, and I cannot do the work for you.
You didn't. I didn't ever ask anyone to do the work for me. That's the whole thing, Your Honor.
Well, you could have
asked somebody to help me. I haven't had any help from the state of Kansas or from Malia Sharp in over a year, and I've raised all three of my kids by myself, and yet I sit here and you treat me like this.
I'm not treating you any particular way.
You have the whole time, Your Honor.
No, I haven't. You expect me to be your attorney and your judge, and you do things outside of the presence of the court and change things constantly without getting the approval of the court. And then you want me to go back and retroactively do things that suit you, and I'm not going to do it.
Your Honor, that's fine.
Okay, so you have a judgment for arrearage that is owed in the amount of $506 back to May 1st, and $506 from this point forward. And you have an attorney that will do an income withholding order to make sure that you get your money. You also have a way that will be tracked through the state to make sure your arrearages are noted, and that every month thereafter, the child support becomes a judgment so that you can collect. You have an attorney that will do any collection efforts necessary if a job changes. You have to notify the court if there are any custody changes whatsoever, because the guidelines now take into consideration the amount of time that any parent has with a particular child. Normally, the court's not in the business of ever dividing siblings, but you have to get permission from the court to do custody modifications, and then Mr. Reddy will be notified and make any appropriate child support modifications that need done. Okay?
That's fine. I'll just make sure that in my next motion, they know that she does not follow any visitation orders. Not one.
Yeah.
Has not kept them overnight and didn't even see them in the month of September.
Okay, here's the deal. This has always been the case. I don't care what anybody's told you for the last
I know no one's told me anything wrong.
years, is that I cannot force parents to exercise their visitation.
I understand.
I can force them to pay child support. She isn't going to get any credit for time, like a shared custodial arrangement, if she's not exercising it. But I cannot force her to exercise visitation of a child.
No, I understand that, Your Honor. I understand a deadbeat is a deadbeat. That's all there is to it. Male, female, it doesn't matter. When they owe and they refuse to pay and they refuse to see their kids because of a boyfriend or a girlfriend, it's on them, not on you. I understand that.
All right. Well, hopefully this will get you all back on track and you know what your obligations are, and that you will either
My obligations have never changed. My kids
exercise them or file a motion to get before the court or consult with an attorney for assistance. If you need to do a contempt citation or something, because that does get a little complicated. All right, Mr. Reddy, do you need anything else from?
Your Honor, I don't believe I need anything else from you. I do believe that Ms. Sharp may have unmuted at one point. I don't know if she has anything to add or if the court would inquire.
No.
I do not, Your Honor.
All right, thank you.
Thank you.
All right.
I guess I do have one other question. Given that there is an arrearage, how would you like the IWO to issue? We will obviously issue for 506 current,
all right,
but what would the arrears?
So May, June, July, August, September, October, November, December. 8 times, or
there will be nearly $4,000 arrearage if there's about 8 months. So I just would like to know how much you think we could include on the IWO.
I'm trying to work on it. 4,048. Well, you know, most of the time it's $50 to $100 that is tacked on, and then of course he can collect any other way that he wishes by garnishing wages or however he wishes to collect on an actual judgment. But I don't know what is the standard for you all now? 100, 150? What are you doing in child support enforcement?
30%, which in this case comes out to an extra $151 per month. But I do often bring this to the court's attention to inquire as to whether or not that's feasible and doable if somebody is paying that much per month.
So what, I'm sorry, what'd you say, 151?
Yes, 30% comes out to 151.
And I said, what did I say, 4,084? Is that right? Something like that.
Yeah, it was nearly that.
Divided by
1,008, Your Honor.
4,008?
48.
48, okay. I'm sorry, I transposed that.
That's okay.
Okay.
It would take a little over 2 years to pay off the arrearage at 151 a month.
Trying to figure out, I can't clear my,
Sorry, I thought so, Your Honor.
can't clear my calculator on my phone. I'm
5256.
okay. Well, I think with him, given the history here, probably you need to pay it off sooner rather than later. I am going to approve the 151 to be added to the 506 for a total of 657, and then there's the, I think, 3% fee.
No fee for DCF collection.
No fee. Okay, good. So that's what the income withholding order will be approved for.
Okay.
Obviously, that can be paid off anytime sooner, but at a minimum, it needs to be paid off at that monthly rate. Thank you for letting me know and reminding me of that.
Yes, thank you, Judge. And I will note, just like you said, if Ms. Sharp, if you wanted to make a lump sum payment to pay down the arrears at any point in time, we would then amend our IWO once the arrears were paid in full, just to hold current support.
Okay, thank you.
Okay, so I ended up on a work phone call during the beginning of this, and I didn't get to watch this earlier. I automatically wanted to be against this guy because of his horrible camera. So it was I guess the mom who's supposed to be paying child support. I guess I messed up on that one, and I can't watch his camera anymore, so I can't deal with rewinding that one back. Let's see what else we got. Who else do we got? We got another Judge Middleton one. This one was a show cause one, and then we've got. Let's jump over to Judge Fleischer. We got a good one. This one starts off with Todd, who's a court viber, stopped by the courthouse and said hi to everybody. It's got his daughter in it and make sure to always be respectful. Todd went and got a picture with Judge Fleischer and got to see the judge. The judge talks a little bit about YouTube and why he's not on YouTube right now. So listen up and you can hear some inside information.
Yeah. Hey, how are you?
Come up. No. You every day. Hi, Todd. Great to see you, man. How are you? Hi, Kennedy. How are you? How about some candy? I've got this, and I've got here's my favorite one. Help yourself as much as you want. I don't have.
Oh, that's okay. I'll just bring that up. No, it's good to meet you.
Yeah.
I've been in that room for probably 6 months now. I don't know how I got addicted to it.
It's okay. We're happy to have you. Just
yeah, it's fascinating. I think it's the way. I think Socksticks came across my YouTube suggestions one day last summer, and then it just kind of grew from there. And I ended up being in the chat with Linus and Dan and all those folks.
And I think that the YouTube thing kind of got really just a little bit. And so that's why what we've done now is I've gone back to live streaming like we did the old way so that people can still, see. Do they? Okay. I just, just things have come across. And so that's why I've kind of, but so what do you tell me about yourself? How old are you? Nice. Are you in middle school now, right? Nice. Great.
A law enforcement officer, and actually thinking more of the courtroom kind of thing.
It's so much fun. It truly is. And if it's so interesting, the people that you meet, the cases that you hear, if you watch, we get all kinds of crazy things that happen. So it's a lot of fun. And the thing is that bye. We'll see you Monday. Have a great weekend.
I think her parents, me and her other dad, would rather be a lawyer than a.
I wanted to be a police officer one time too. And, when I was growing up, I was your age, I used to watch Cops all the time. I was so hooked on all those shows, but when you grow older, you'll see you change. Your taste will change. What you like changes. You might not like mushrooms when you're that age, but then when you get an adult, it's your favorite thing in the whole world.
She's definitely trying to figure that out.
Yeah.
I may come back Tuesday. My son kind of wants to come here, so
That'd be great. We'll be here. I'll be here all next week.
Victoria down. I think she's off today.
Vic will be back Monday, right? Yeah, so bring, and I didn't know that. Yes, let's do it, of course.
What time, what day? Because I have to go somewhere.
Yeah, the reason we're in Texas is, my husband, he's in, cancer treatment in Indiana.
Sorry to hear that.
So he's gonna be in an apartment here.
Yeah. Where's your photos? This is not, I don't know your phone. We have two different, I have an Apple. One, two, cheese. That's so cute. Okay, do y'all want to do a different pose?
No, that's good, that's good. Yeah, thank you, Judge. Have a good weekend.
No, but if you want to come back next week, we always start around 9-ish.
Right.
And then you can come hang out. We'll let sit in the jury box. You can watch in the jury box and kind of hang out.
Yeah. Yeah, definitely. He's 12. He's 12.
Great, come back. We're happy to have you. I mean, school's still out for now, right?
Yeah, we don't go back until like the 4th of January. We go back to Memphis, 4th of Memphis, so.
Wow.
We're here for
Just for the children.
Indiana, yeah, so, anyway.
Well, tell him I wish him the best of luck. I hope he gets and everything.
Yeah, it's looking up. Even after 2 weeks of treatment and everything's getting better.
Great. Good. Well, we're knocking on wood for you. And then we'll see you next week.
Yeah.
Okay, great. Hey, Val, do you have a new case?
I do, Judge.
You ready?
Mr. Baldwin, Alonzo Baldwin.
Okay, very much, please.
How's your holiday, Judge?
Hey, how are
So
you?
far, so
How's it
good.
going?
Uneventful, which is good.
Yeah, that is good, right? And you're here, so that's good too.
Good enough.
That's okay. Are you here for you or for someone else? You here? This is for you. Okay. All right. Good morning, Mr. Baldwin. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 22nd, 2024, the officer conducted a traffic stop on the defendant's vehicle at approximately 2:11 a.m. after observing it drive northbound on a southbound only street at the 1000 block of Durham Drive. The officer observed the defendant to be the driver and sole occupant of the vehicle, and the defendant admitted to drinking and advised the officer he was coming from a few bars on Washington Avenue. The officer observed the defendant to have bloodshot eyes and an odor of an alcoholic beverage and was swaying while standing. Standard field sobriety tests were performed. HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused. Blood search warrant was signed and executed.
What's the stop for again?
Driving north on a southbound only road.
Got it. Okay. Mr. Baldwin, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're consuming alcohol or illegal drugs, I will issue a warrant for your arrest, put you in jail. Do you understand?
Sir.
You run his license.
Your Honor.
All right. As long as you have liability insurance in your name, you may continue to drive as well. You need car insurance. If you don't, then you're not allowed to drive. Do you understand? Okay. Now you've got a great lawyer. He'll take care of you. You got to stay in contact with him. If Val tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Not hard. Don't drink, don't use illegal drugs, and stay in contact. We good? All right, come on. Thank you.
So I'll just put it on the computer. It's okay.
So Vicky, the judge says that he's not doing YouTube, that he's putting it back on, he's doing it on Zoom. He's doing it the regular way that he used to do it beforehand whenever Kathy first found him and introduced the world to us. It's a lot harder to get him now, but it just kind of blew up too fast, causes too much trouble. That's the reason he gave Todd. I trust him with his answers, but in the end, if it's a distraction from what he's doing, if it's a distraction from his goal, well, Vicky, we're going to put out a video every day with some of the highlights on it, but just to give you a heads up, if you go to Kathy's Court Vibes in the morning at 4:30 in the morning Eastern time, Now, Kathy does something special for us is she leaves them up there all day. So if you can't get up early, you can always watch it on replay, and she'll have some of the greatest highlights from it. But you can watch it live on Zoom. It's not as great. It's hard to watch it on TV, but it's still something. So we're going to jump back into it and see what left us on Friday.
Ready?
Bottom of page 1, Milo. Andrew.
I'll look at
Ramona, are you ready?
Yes, Judge.
You ready? Yeah, okay. Andrew Aravallo.
Yes.
Mr. Aravallo, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 20th, 2024, officers responded to a residence in regard to a shooting that just occurred. The officer stated over the radio that concerned citizens pointed out a motor vehicle involved in a possible shooting. The officer followed the motor vehicle and began calling out the direction of the motor vehicle. A felony stop was conducted, and the defendant, 17 years old, was in possession of a handgun with a sling.
Someone saw him get in the car and go?
It just pointed out the vehicle that was involved in a possible shooting, and the officer was following that vehicle.
So someone saw a shot from the car.
All it says is that a concerned citizen pointed out a vehicle that was involved in a possible shooting.
You gotta love that look the judge is giving.
Let's do this. I'm going to appoint him a lawyer, and then I'm going to have the lawyer look in, and then we'll go revisit here. Ramon, do you mind appointing Mr. Mr. Aravallo a lawyer, please?
Okay, Judge.
Mr. Aravallo, take a seat for me in the jury box, please.
Sure.
Okay.
This is Mr. Billsong, Your Honor, on page 3.
All right, Mr. Bisson? Mr. Bisson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 21st, 2024, the officer conducted a traffic stop on the defendant's vehicle at approximately 1:24 a.m. after observing it travel 104 miles per hour and 96 miles per hour in a 60 mile per hour zone. The defendant was found in the driver's seat of the vehicle with one adult passenger. Upon contact with the defendant, the officer observed red glossy eyes, slurred speech, and a strong odor of an alcoholic beverage. The defendant admitted to drinking. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 1 out of 4. Inventory of the vehicle revealed a bottle of cognac directly behind the front passenger seat on the floorboard, approximately 1/4 full. DICs were read and the defendant consented to breath. The results were .089 and .095.
DIC, prior DWIs, and does he have a license? Please?
There's no prior DWIs, Your Honor, and license is eligible.
Mr. Bisong, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? You also are not allowed to drive unless you have liability insurance in your name. You understand? These are your bond conditions. As long as you can abide by these bond conditions, you and I will be fine. Otherwise, I'm going to end up putting you in jail. I'm not asking much. We're going to reset your case to give you time to hire a lawyer. So I will have you go to Ramona, sign a reset. After that, you'll get with Francis for your bond conditions, and then you're free to go. All right, please. Rory, what are you waiting on? Do it. Is that it? You done now? Yeah, go. Thanks, you too, Lauren.
All right.
Ready?
Well, our next one is Charles on 4.
All right, Kevontae Charles, come up. Good morning, Mr. Charles. Sir, you were charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 22nd, 2024, officers were dispatched to check by a unit regarding individuals fighting at a parking lot in Harris County, Texas. The officer in full uniform observed a large group of individuals circled around 2 individuals fighting in the lot. Officers dispersed the crowd and attempted to detain the defendant. The defendant looked at the officer and attempted to leave the scene because he did not want to speak with the officer. The officer informed the defendant he was not free to leave, and the defendant started to run away on foot from the officer while the officer told the defendant to stop running. The defendant ran approximately 2 blocks or 500 feet.
What was he doing wrong? Just standing?
He was engaged in a fight with someone else.
Was he the one that was actually fighting? Didn't seem like it. If he's just a spectator, he's doing nothing wrong. Unless you...
After he dispersed the crowd, he attempted to defame the defendant who was involved in the fight.
Okay. Mr. Charles, I'm going to find that there's probable cause to go forward with your case. Just be careful, you know, really. I'm not going to put any conditions on your bond. Just be careful. Don't pick up any new cases. That's all we're asking you to do. All right. We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Ramona, sign a reset, and after that, you're out of here. You are Gabriel Johnson.
Yes, sir.
Mr. Johnson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
On December 21st, 2024, at approximately 12:04 a.m., the officer conducted a traffic stop on the defendant's vehicle after observing it travel approximately 78 miles per hour in a 65 mile per hour zone. And after a check on his license plate revealed it to be expired as of June 2024. The officer also observed the vehicle insurance status to be unconfirmed. Upon making contact with the defendant, the officer observed bloodshot eyes, droopy eyelids, slurred speech, a strong odor of an alcoholic beverage, and noticed the defendant to be swaying while standing. The defendant also made nonsensical statements and yelled at the officer during standard field sobriety tests. The vehicle smelled strongly of marijuana, and there were burnt marijuana blunts in the vehicle's driver door pocket. The defendant admitted to drinking, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 2 out of 4. The DIC was read but refused. A search warrant for blood was signed and executed.
Okay. Any prior DWIs?
No, Your Honor.
License?
Eligible.
Mr. Johnson, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. No more PR bonds.
Yes, sir.
If you do not have liability insurance in your name, you are also not allowed to drive, and I'm making that a condition of your bond. Do you understand?
Yes, Your Honor.
Okay. I'm going to have you come up to Ramona. We're going to have you sign a reset. Ramona, it looks like he has a lawyer. I guess you want to wait a little bit to see if someone comes. So what we'll do is I'll have you meet with Francis for your bond conditions. We'll have you take a seat while we wait for your lawyer to get here.
Thank you.
Please.
Be top of page 14, going back to Machado.
Oh. You're Eric Machado. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 21st, 2024, the officer responded to a major crash at Interstate Highway 45 in Harris County, Texas. The officer observed 3 wrecked vehicles, including the defendant's vehicle. The officer discovered the defendant's vehicle was driving at a high rate of speed and struck the rear of another vehicle, which was pushed across another lane and subsequently struck another vehicle. The officer made contact with the defendant, the driver, and the officer observed staggering, the defendant trying to sit on the ground due to poor balance, a strong odor of an alcoholic beverage, slurred speech, and bloodshot glossy eyes. The wheel witness, the passenger of the defendant's vehicle, observed the defendant drink 3 40-ounce Smirnoffs and stated the defendant insisted that he drive as the big brother. The wheel witness stated the defendant did not stop at a red light at an intersection, hitting another vehicle. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant read the DIC and consented to breath. Those results of the breath test were 0.058 and 0.054. A DRE and blood sample were requested, to which the defendant consented. The DRE determined the defendant showed signs of being the influence of a narcotic, analgesic, and dissociative anesthetic.
Got it. Mr. Machado, I'm going to find that there's probable cause to go forward with your case. Have you prior to the DWI's license?
No DWIs, Your Honor, and eligible license.
Mr. Machado, I'm ordering you as a condition of your bond not to drive any vehicle that doesn't have insurance with your name on it. Do you understand? If you're caught driving a vehicle and you don't have insurance on it, I'm going to put you in jail. No more PR bonds. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, into jail you will go. No more PR bonds. If you don't have anyone to pony up $5,000 to $10,000 to get you out of custody, you'll be sitting in there until this case is over with. Do you understand?
Yes, sir.
How old are you, sir?
26.
What do you do for a living? Sorry?
Paint helper,
Okay. What kind of money you make?
now 15 an hour.
Okay. And who do you live with? All right. We're going to give you time to hire a lawyer because you need a lawyer to represent you. Don't wait. There's a lot of timing requirements with the DWI. So don't sit and wait a month, 2 months because you're only hurting yourself. You understand? All right. I'm going to get you to Ramona. We're going to have you sign a reset. Then you'll get with Francis for your bond conditions. And after that, you'll be free to go. Don't pick up a new case and don't use. All right.
Austin on 17 is going to be our next one, Your Honor.
All right.
Austin.
Good morning, Mr. Is it Poston or?
Poston.
Poston. Mr. Poston, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to a residence in Harris County, Texas, in response to a family disturbance. The reportee stated the officers that the defendant had engaged in a physical altercation with multiple complainants. The second complainant told the officers that her and the defendant, her stepfather, got into a physical fight and that the defendant pushed her, but did not cause her to fall to the ground or did not cause any pain. The officer then contacted the first complainant, the stepmother of the second complainant, who stated to officers that after the fight, she walked outside the residence to get in her car when the defendant pulled out a pocket knife and stabbed 2 tires on her vehicle, causing at least $200 in damage.
Mr. Poston, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with the complaining witness in this case and not to be in possession of weapons. Do you understand? You violate these conditions, I will put you in jail. You will not get any more PR marks. We are going to reset your case to give you time to hire a lawyer. So I'm going to first have you go to Ramona, sign a reset. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go. When you come back, please have a lawyer. Can you file that, please? No contact in the weapons.
Rada, on page 18. Okay, you go to the next one.
Racino on 18 also, Racino.
You, Luis Angel Racinos.
Yes, sir.
Mr. Racinos, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Linda in Boston. That's awfully nice of you. And you got some good names in there. You got Sherry K. That's my buddy. Ellie in Chicago, Amanda E., Rita Odom, and Dale. Got some good names in there. So thank you so much.
On December 20th, 2024, the officer was dispatched to Fondren Road to meet the firefighter call. Upon arrival, the officer was advised by a Houston Fire Department medic that the defendant, who was the driver and sole occupant of the vehicle, was asleep behind the wheel of the vehicle while the vehicle was on and in drive and in the middle of the intersection. Upon contact with the defendant, the officer observed slurred speech, a strong odor of an alcoholic beverage, and swayed balance. The defendant denied drinking. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused. Blood search warrant was signed and executed. During the reading of the DIC, the defendant wet his pants for a second time.
Mr. Racinos, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're going to be randomly tested. If I find that you're consuming alcohol or illegal drugs, you will go to jail.
Eligible license and no priors.
Got it. If you don't have liability insurance in your name, you're not allowed to drive any vehicle. Do you understand? And that is also a condition of your bond. We're going to give you time to hire a lawyer. So I'll have you sign a receipt with Ramona. After that, you'll get with Francis for your bond conditions, and then you'll be free to go. Don't pick up any new cases. Do you understand? Okay. Come on.
Alpha 22 is our next one. Oh, come on, sorry. I want to after that.
Is it Saquital? Saquital?
Sakital.
Saquital?
Sakital.
Say it again.
Sakital.
Okay, Mr. Saquital, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On December 21st, 2024, officers were dispatched to a firefighter call for a person down at approximately 1:24 a.m. Houston firefighter advised the officer that he observed the defendant to be asleep behind the wheel of his vehicle, despite attempts to wake the defendant with their horn. When the officer arrived on scene, he observed the defendant inside his vehicle while the vehicle was on and in park at the 4300 block of Bylock Road, and the defendant admitted to drinking about 8 drinks and stated he had just left the sports bar. The officer observed the defendant to have glassy eyes, poor balance, and an odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 2 out of 4. While inventory of the vehicle, the officer located one open 12-ounce Coors
Thank you,
Light can in the
Darrell.
center
Thank
cup
you.
holder, which was 1/4 full and cold.
Drinking while driving?
Yes, Judge. And the defendant, and the DIC was read, and the defendant consented to breath. The results were .087 and .08.
Mr. Secretary, I'm going to find that there's probable cause to go forward with your case. I'm now taking away your privilege to drive. You are not allowed to drive whatever for any reason. Do you understand?
Yes, sir.
You will be signing an affidavit with me today, promising me you're not going to drive, and I don't care what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. I don't care what your reason is. There's no justification you can give for getting in a car and driving. Do you understand?
Yes, sir.
And Kimby, that's a good point. I never really noticed a difference in it. The way Judge Fleischer gets upset if they have alcohol in the vehicle while they're driving. I truly didn't know that there was a big difference between drinking at the bar than driving, or drinking while driving. I didn't really catch the nuances in that until watching Judge Fleischer and seeing just how upset he gets whenever someone's got alcohol in the vehicle with them. It just puts him on a whole nother level. So yeah, that was a good catch on your part there, because he does not like that at all.
This is a court order. This is an affidavit and promise you're making to me now that you're not going to drive. Heed this warning. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds. We are going to reset your case to give you time to hire a lawyer, so I'll have you swear to this. We'll get you to Ramona with your reset, and then Francis for your bond conditions.
Were you gonna need Mr. Rada to stick around? For,
No, because I can just tell Carl.
okay. Yeah, he's already got it.
Are you Miss White?
Yes, sir.
Ms. White, you were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. Your case is 227 days. Don't say anything. Just take a seat for me at the jury box. I reached out.
Oh, you did?
Let's see what she says. I don't know. I just did.
Judge, do you have?
I have 2 more arraignments, and then I have a warrant that walked in from yesterday, and then
Let's finish with the arraignments first.
our next one is Willis on page 24. Ms. Willis.
Are you Taisha Willis?
Yes.
Ms. Willis, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was dispatched to a residence in Harris County, Texas in regard to an assault. The complainant, the defendant's daughter, told the officers that her and the defendant got into an argument and the defendant struck the complainant in the face with her hand, causing pain. The complainant and the defendant then began fighting. Multiple witnesses told the officers that the defendant was the aggressor and hit the complainant first.
Ms. Willis, I'm going to find that there's probable cause to go forward with the case. What's the relation?
It's the defendant's daughter, Your Honor.
Do we know whether the daughter wants to have contact?
Your Honor, we have not had a chance to reach out to the complainant yet.
I don't know if she wants to have contact with you. So until I do, I'm barring you from having contact. You understand? There is a protective order that has been entered in this case. I would get to know it because if you violate the protective order, the state can file additional charges of violation of protective order against you. And it's one of the worst cases you can pick up in misdemeanor court.
Can I question something? You said that it was a residence, that we were in a residence?
Let's not talk about the case now. Now's not the time. I've got DAs here. Anything you say, they're going to use it against you, even if you think.
It's a Walmart, not a residence.
Doesn't matter. Just don't. So what do you do for a living, ma'am?
Drive school buses part-time.
Okay. What kind of income do you have?
Part-time, it's like probably less than 18 a month.
Okay. Do you have the ability to hire a lawyer?
No,
You want to apply for an appointed lawyer?
it'd be fine.
Okay. I have it on file. So I'm going to, for now, ma'am, I'm going to have you go to Ramona, sign a reset. We'll have you take a seat in the jury box. I'm going to have you sign bond conditions. You're not to have contact with her and no weapons. And then I'll try to find you a lawyer. Okay?
Okay.
Please.
Flip it the mullet.
What do you need me to do? Should I be filing?
Do you wanna, she's not supposed to have contact, I mean.
Well, we haven't had contact with her. I don't know if she wants to have contact with you, you know? I was going to say no for now until we know. Can you file a new MOA, please?
Yes, Judge.
Be filed new, I'll just put the original.
You can, so no?
No.
No? Okay, don't worry about it.
Yes, Judge.
Okay, last one.
Are Miss Young on 25?
Okay. And the Young.
Yes, sir.
Ms. Young, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 21st, 2024, the officers were dispatched to a disturbance call at 11:03 p.m. in regard to an intoxicated female who had become violent. Upon arrival, the officer made contact with the complainant, a supervisor for Acadian Ambulance, who stated that he observed the defendant throw a rock into the windshield of a Chevy pickup and then run off. The complainant advised that the defendant used to work for Acadian Ambulance and was no longer with the company. The complainant estimated the damages to be in the amount of $500. The officer observed the Chevy pickup truck with a broken windshield.
Got it. All right, Ms. Young, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using alcohol, I'm going to put you in jail. No more PR bonds. Do you understand? I'm also ordering you not to have contact with the complaining witness in this case, not to be in possession of any weapons as well. So Francis, this one, I need you, since we're monitoring her for alcohol and drugs, please. Okay. What do you do for a living, ma'am?
I did work at Acadian Ambulance, like you
You're
said.
working now?
At an interview yesterday, they said I would be hired on. I guess it depends on also the background check. If they're okay with that.
My question is do you have income coming in?
I will be, hopefully.
Do you have the ability to hire a lawyer?
Yeah, I will.
Okay. If you have any issues, just come back and tell us. For now, we'll give you time. So I'll have you sign a reset with Ramona. You'll get with Francis for your bond conditions, and then after that, you'll be free to go. Don't use alcohol. Don't pick up a new case, because otherwise I'm gonna end up putting you in. Do you understand? Okay, ma'am, please.
Okay, that was it for Judge Fleischer. Hey, there's a little bit of discussion in there about memberships. Just to give you guys a heads up, just come and watch the show. The memberships are awesome. All channels appreciate it and all that, but you coming and watching and being part of the community is so much more important than any monetary gift. In the end, YouTube should pay the creators for putting up the content so they can put the commercials on it. Those of you who are paying for YouTube Premium, y'all spend money on it. I'm just glad to have you guys here. I'll give you all a heads up. The screen that I'm actually looking at, I can't see what's green or gray or anything like that. I can't see any of that. I can't even see which ones are moderators. I know the moderators by name, but it doesn't tell me who they are. So in the end, none of that matters. We're just glad to have you guys here. And Kelly, no, it won't allow me. I can't even buy memberships on my own channel. I don't know why, but whenever I go to the $sign thing, it allows me to buy myself a super sticker, or it allows myself to buy a super chat, but I cannot buy any gift memberships. I've talked with YouTube. I've actually sent screenshots to Fozzie to see if he could help me, because he's worked with Kathy before on it. But there's YouTube does what it does, and it's kind of goofy and crazy. So, but yeah, I'm just glad you guys are here. It means the world to me, and it means the world to the moderators too. They've seen us build this up, and they've seen it get bigger and bigger, and so it's great that we do that. Let's go to Judge Middleton, and then I'm gonna get out of here. So we got Judge Middleton. We got a show cause hearing. It's always fun to see Deborah Davis back in action again. And I started to think, I know I watched this today. I don't think we watched this one. We watched the one where the guy accused Judge Middleton of letting his sister's attacker go. But this is another one. This is one where somebody ended up getting killed in an accident, and so the guy won't stay off drugs. So here we go with that.
This is file number 242131FT, People versus Logan Keith Thomas. That's you, sir? You're here with your lawyer, Mr. Anastasi Marku. Also present is Prosecutor-elect Deborah Davis on behalf of the people. Mr. Logan, let's start at the beginning. You got charged in a complaint that was authorized by Ms. Davis earlier this month. Count 1 is operating with a suspended, revoked, or denied driver's license causing a death. It's alleged that on December 2nd, in a snowstorm, that you were driving with a suspended license, and by the operation of that vehicle did cause the death of a young man named Anthony Miller. Second count, you were operating the vehicle without any insurance. We get lots of people doing both of those things, driving suspended and driving without insurance. When there's a death, it becomes a felony, punishable by up to 15 years imprisonment and a fine of up to $10,000. You're also charged as a fourth habitual offender, making it theoretically punishable by up to life imprisonment. You were arraigned on that charge, and bond was set by me in the amount of, I believe it was $75,000 cash or surety.
I think it was 100,000.
100,000. Yes, there it is, 100,000 right in front of me. I ordered that you not use any drugs or alcohol. I ordered that you possess no weapons or firearms, no assaultive behavior, wear a GPS monitor, and no driving. I also ordered that you must report to the day reporting center on the very next day and sign the condition to agree for testing. So you did, I believe you're on the GPS monitor now, and you signed that on December 3rd. You and I were, I think, over the Zoom feed. I appointed Attorney Ross Truckee to represent you, and there were records made at that time that I set the bond about some previous fails to appear, possible case out of California, a driving suspended ticket in Kalamazoo from November. So bond was set in the substantial amount of $100,000. Pre-exam conference was originally set hard to do this in electronic form.
So Nan, you mentioned that Debbie Davis is back. Hopefully their office will run better. So far, I've already seen her a few times. Anybody who's got any sort of sexual assault or anybody who's got any sort of violence towards women, she's been doing everything she can to lock them up. So she is doing exactly what she promised during her campaign. She did exactly what she promised, to lock up the bad guys and not give them any slack. And so I applaud her for that. Thank you so much, Linda. Thank you. We're starting to love Boston even more. We're going to throw away our Yankees hats. I don't have a Yankees hat, Linda. I'm sorry. All right, let's see what we got here.
For an earlier date, it's presently set for January 7th, which is my day. As I indicated, Mr. Truckee was counsel at that time. There was discussion that you were in discussion with the Levine and Levine law firm, the Marcoux law firm, and that you were going to be retaining Anastasia Marcoux, and he's here with you today. Sometime last week, I think this substitution was executed. It hadn't made it to the file at the time I dealt with this last week. There was a notice that we received on Monday, December 16th from the Day Reporting Center. It was Monday, December 16th was the date of the test. It was filed with the court on December 20. Well, it was filed with somebody, I guess us, on December 21st. December 21st was Saturday. So I don't know when we saw it. We first saw it on the 23rd. Ms. Davis saw it, and she moved to cancel your bond. She filed a written motion to cancel the bond, indicating that you should show cause why you should not be brought before the court for bond violation. The test
There's actually, the test was on the 16th.
16th.
The notice of the results was received on Thursday, the 19th.
All right, the one we had has a date of the 21st on it, which is a Saturday. You might have got it before we did.
That's, I think, when Pam from DRC emailed it to everybody, was on Saturday. I had gotten it from them on Thursday prior to them filing that motion.
I think that's correct. The test printed result is from the 19th. However, the test is from the 16th. I don't know when either the prosecutor or the court received those results.
All right. Now, we had a very short notice emergency hearing on Friday afternoon or Monday, the 23rd, the last day before the Christmas holiday.
Typically, it was on the 19th.
No, it was the 23rd. Oh, no, you're right. It was, let me look at my note here. it was on the 20th.
Yeah, that Friday.
Friday, not the Friday, I wasn't here Monday. It was Friday. It just felt like the last day because it was my last day. So we had an emergency hearing, show cause why bond should not be revoked. Notice was not given. They attempted to, but Mr. Thomas wasn't here. Mr. Marku wasn't here. And Mr. Truckee wasn't here, and neither was a public defender. I learned that a substitution was forthcoming, and Ms. Davis cited the court rule that allows the court to do a bond violation. I was not clear and still wasn't clear what my authority was to immediately revoke bond without any sort of hearing or due process. So I set the matter for hearing this morning. Ms. Davis represented at that earlier hearing that the laboratory reports have come back regarding the defendant's drug and alcohol tests at the time of the accident, and that they intended to be amending the charges. The petition to revoke the bond and the motion to cancel bond states, and on 12/19, the prosecutor received the MSP lab report. Now that would be for the actual driving, indicating the defendant at the time of the accident was positive for methamphetamine, fentanyl, and morphine, as well as amphetamines. They also allege that you have 3 previous operating while intoxicated convictions. And that on the 19th, the results were received back from the Day Reporting Center that you tested positive for methamphetamine and amphetamines on December 19th. Ms. Davis obviously was not very happy about that. Frankly, neither was I. And she asked me to revoke your bond. And is that still your request here, Ms. Davis?
Yes, Your Honor. Just to kind of clarify, bring the court up to speed too. We haven't amended yet because we're waiting for the computer crimes unit from MSP to give us the report on the telephone usage, which could end up resulting in an additional charge of reckless driving causing death. So at least the amendment now that we know will be happening is OWI causing death, which is a 15-year as a habitual fourth, and OWI third, which would be a lesser included, depending on how that comes out, which is a 5-year, but also a habitual fourth. With the bond conditions that have been in place, it's my understanding from Attorney Marku that defendant has not been tested since the 16th. And so I guess part of our discussion prior to the hearing was, I'd like to have him test right now. And if it's a positive, then I would still be asking for his bond to be canceled. And if he passes it, I would leave it to the court's discretion as far as a punishment or some sort of repercussions for the use of illegal substances while on bond. Obviously not immune to the idea that, with a recovery and relapse do happen, but this is a very serious situation. And Your Honor was obviously less concerned about the use because he wasn't driving, but we can't guarantee that he's not driving. We do have the GPS tether on him, which has been effective. And so we can kind of keep an eye on where he's going. But we really would like to get a handle on the substance issue. I also, in the emails with Pam from DRC, trying to get a handle on how they're doing the testing and what they're testing for. They are not testing for all of the substances that he was positive for at the time of the crash. So the test that they're using will not detect, I believe, fentanyl and maybe morphine. So they can do a 14-panel instant test. They typically only do the 5-panel, and then the alcohol test. I would ask that the court amend the bond conditions if he is going to remain out on bond, that he be required to do the 14-panel instant test and the alcohol test, and that it be on a regular instead of the random call-in, basically no less than 3 times a week, because these types of substances will typically remain in a system for up to 72 hours. If we do the 3 times a week testing, we should be able to monitor it pretty safely. So with that, I leave it to the court's discretion. Thank you.
All right, well, before you speak, Mr. Marker, let me say one more thing. One of the concerns I had is that you were in custody from December 2nd. You posted bond on December 13th. So you were in custody for 11 days. The test that was positive was on December 16th. So it would be 5 days after you got out of jail, you tested positive for methamphetamine. Let me look at it again. And amphetamine, I think. I keep having trouble finding that DRC file. Now, that isn't evidence at this point. And the concern was that there's no testimony or evidence regarding that, but based on our knowledge from dealing with these sorts of things on a daily basis, methamphetamine doesn't stay in your system for 15 days. So the obvious concern was, and my concern and Mrs. Davis's concern, is you got out of jail after 11 clean days and immediately relapsed. What you're charged with is driving suspended with a death, which is a 15-year felony. As a habitual felon, makes it punishable by up to life imprisonment. In my mind, it's worse if you're intoxicated or under the influence of drugs causing a death, but it's the same offense. It's a 15-year felony. The time I set your bond, I didn't know whether you had alcohol or methamphetamine or, heaven forbid, fentanyl in your system. So the concern is that between the time you got out and the time you tested 5 days later, you'd started using again. And that is our concern. Mr. Marcoux?
Your Honor, I would ask the court to consider following the, for want of a better phrase, game plan that Ms. Davis outlined for the court. He's ready, willing, and able to test right now. I am optimistic he'll test negative for all controlled substances. If he does not, then I understand the court's decision to revoke and Ms. Davis's request to revoke. He has been attending AA, NA. I have proof of that. He has been calling the day reporting center every day since then to be able to test, but for whatever reason, because it's random, his name has not come up. I've also confirmed that in fact, he has not been driving to work. He's been getting rides from co-workers and otherwise. So I would ask the court to consider that particular plan. And obviously what I told him this morning was if the court were to give him any consideration and not revoke bond, that he would have to test more frequently. The test would be broader spectrum than it currently is. And that if he is either, if he doesn't test positive, or is found driving, that at that point, the expectation would be that his bond would be revoked no matter what. There wouldn't be much argument on either way. So that is my proposal at this point. He understands that there has to be a short sanction. My concern, Your Honor, and it's not, I don't know if it's a legal argument, I don't know exactly how to phrase this, but it's disturbing that somebody signs a bond condition that talks about testing positive, you get 24 hours, 48 hours. It almost gives a sense of like a, I don't want to say a pass, but it basically gives somebody notice that this is what's going to happen to you if you test positive. And unfortunately, it can possibly create a risk that somebody thinks that's all that's going to happen to them.
Well, that's an old form.
Yeah, and I think we need a new form on this case.
And it doesn't have any due process, you know, if there's a problem with the test. Well, first of all, let's see whether we've got somebody to do an instant test. All right, we've got somebody that can do an instant test on Thomas Logan. That's fine. It's casual post-Christmas, but so are Dan or Matt there? How are you gonna do it? That's for fentanyl and methamphetamine.
I'm gonna pause it there real quick. You gotta love how casual this court is. You gotta love how the judge can just pick up the phone and make that call like that and try to get that done. It's almost like he's calling the CVS pharmacy down the road.
All right, well, let's try that. All right, thank you. All right, bye.
Your Honor,
Yes.
just to clarify, what is the level of testing that we have here? Is it
Well,
just
all
the
we have
5?
right now are the instant tests. If you want him to go to the day reporting center and come back, we're gonna sit here for an hour.
No, and I guess what my thought was is we do whatever instant test we have here,
Mhm.
assuming that that is negative for substances. I would still ask that he go and test at DRC with a 14 panel
Okay.
today so that we can get him on a more regular schedule.
All right.
Thank you.
Mr. Logan, this is very serious business. This is essentially a homicide case. The maximum punishment is up to life imprisonment. And the facts are terrible. The closer you look at it, the worse it gets. There's a lot of public interest. There are a lot of families that have interest in this. Everybody at the school, everybody in that neighborhood. And so the feeling is if you're going to be out on a substantial bond and just using meth, we might as well just cancel your bond and let you sit. When bond is canceled, in theory, the prosecutor has to bring the case to trial within 90 days or a bond needs to be set. General rule in a felony case is if the defendant's unable to post bond after 180 days, they're entitled to have a bond set. If bond is denied, you're entitled to either have a bond set or have the matter tried within 90 days. When I was prosecutor, I used to welcome it. I said, yeah, we'll try this in 90 days. But it's not always possible in this kind of case. They're awaiting laboratory reports regarding substance abuse. They're awaiting probably autopsy reports, accident reconstruction reports. These kinds of cases can take time. And because of the seriousness of it, the prosecutor charged this most apparent offense, driving with a suspended license, immediately, thinking they'd wait until the other stuff comes back. So I'm going to send you out with Ms. Kiefer from the probation department. We'll do an instant test. Your test for methamphetamine is going to be negative. Is that correct?
Yes, sir.
When did you learn that your test was positive?
Thursday, I believe, last week.
Right now, I'll just leave it at that. The last thing you need in your life right now is methamphetamine, closely followed by fentanyl. That's a fairly recent phenomenon where they're combining a powerful stimulant like methamphetamine and a very powerful depressant like fentanyl. That's why we have so many people dying. All right, I'll suspend the record here for a moment. You go here in the back. All right, I'm gonna stop the live stream also.
All right, and there we go. I didn't get anything coming back on that, but I got a feeling he knew he was going to pass it. That's why he was willing to take the test. And you know, if you give somebody enough time, they can clean out their system, especially with a lot of that stuff. So, but I'll do a little bit of research and see if anything come up on that. I got a few folks that'll research all that up for me. But you're absolutely right. It's awesome to watch Judge Middleton's wisdom. He keeps it plain, keeps it simple, but he's certainly one of the good ones, and he doesn't hold back. The one earlier when he was reciting the Billy Joel lyrics, if that guy would just let off the edge and just shut up and listen to the judge, he'd probably be doing so much better in life. I know that county's going to miss when he's not there. Well, that's it for us tonight. We will see you guys tomorrow night, same time, same place, 8 o'clock Eastern time. See you.